our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
Some people are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property, okay? Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, good morning, everybody. Welcome to the show. Today, we're talking about the impact of South Carolina's new law and regulations on wholesaling. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel. You can find us on YouTube, Facebook, and X. You can find us at the handle @InRem Podcast. That is @InRem Podcast. Also, you can download an audio version of the podcast. Sometimes that's an unspoken kind of part of the podcast. We don't talk about it a lot. But we're getting more and more downloads each and every week. So if you go there, download it on Apple or Spotify, leave us a review. We would greatly appreciate it. It helps us out a ton. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So our legal update today is answering the question, what is the lis pendens and when is it used? So a lot of people are confused between the idea of a memorandum of, say, a purchase contract or an affidavit of a purchase contract and a lis pendens. They are both recorded documents or can be recorded, but they are for two separate purposes. So first, your memorandum or affidavit is a document that's recorded to basically provide the world notice that you've entered into a contract to purchase. In Arizona, we have pretty strict laws on when you can record these memorandums or affidavits, and there's certain requirements you have to comply with. And if not, there could be, pretty significant penalties for failing to comply. A lis pendens is also a recorded document, but it's a document that's recorded upon the filing of a lawsuit that will impact or affect title to real estate. So notice of lis pendens basically means notice of a pending lawsuit affecting real property. And so in order for you to record a notice of lis pendens, you actually have to file a complaint with a court of competent jurisdiction. And then that complaint has to allege some claim that if the outcome is determined in the favor of the plaintiff or the party bringing the lawsuit, it could impact the title to real estate. And if you properly allege that claim, you can then go forward and record upon the filing of the lawsuit a notice of lis pendens, which basically says, hey, look, world, if you're going to come and you're going to be interested in this property, take a lien against this property, buy this property, just know that there's this lawsuit pending and you're going to take your interest in the property subject to the outcome of this lawsuit. But it's very important that the lawsuit actually allege a claim that's going to, the outcome of which is going to affect title to real property. I've seen, and it's a mistake, and attorneys and their clients have ended up in hot water where they bring a lawsuit, and the lawsuit may arise out of a contract involving real property, but the lawsuit is one for damages. And they're not seeking any type of relief with respect to the property, but they go ahead and record a lis pendens anyway. Or I've also seen it, and this is even more extreme, where they've actually recorded a lis pendens when the complaint doesn't even involve a contract with respect to involving real property, and simply seeks money damages, but the plaintiff wants to be able to secure their judgment or soon to be issued judgment against the defendant's real estate. And so they go and they record a lis pendens against the real estate, even though the action is not one that's going to affect title to real property. In those circumstances where it is recorded to try to just, encumber real estate for the recovery of money damages, that's a wrongful recording. And as a result, here in Arizona, you could have the attorneys and their clients in hot water. And what that means is basically there could be sanctions for wrongfully clouding title to the property. So sanctions include treble or triple the actual damages, statutory damages of $5,000, plus the having to pay the property owners attorney's fees and costs incurred in having that list pendants removed from record or from their property. So it's not something to be taken lightly, the recording of list pendants. But basically, to answer the question, what is a list pendants and when it is used? A list pendants is notice to the world that there is a pending action affecting title to real property, and it's recorded only upon the filing of such a lawsuit.
All right. Thank you, Sean, for the legal update. With that, let's go into a couple announcements. Every Tuesday, today is that day, 2 p.m. Arizona time, we have the Creative Finance Collective. Make sure you're there for that. So what is the Creative Finance Collective? That is a chance for attorneys or basically professionals in the space of creative finance, not just in the state of Arizona, but in all states and for all lawyers that want to participate in that, to get together and talk about what they're seeing with regard to the laws in their respective states, what they're seeing with clients, problems, successes. But it gives you a chance to hear lawyers discuss creative finance from the perspective of a lawyer. We talk about the risks, the rewards, the advantages, the disadvantages, so on and so forth. But what we also do is make ourselves available to you, the listener, for an entire hour. So really what we're about for that hour is engaging with you, the listener, talking through issues or questions that you have specifically about the area of creative finance. So if you got those questions or you have an interest, make sure to join us. 2 p.m. Arizona time, live, and that'll be on YouTube, Facebook, and X. You can go to any one of those, join us. We'd love to have you. And we're there for as long as we're getting questions. So it's a good time to go through that. Also, if you have questions for today's episode, we're talking about a real specific topic in a real specific area. So if you have questions, make sure to post those in the chat. We'll get to those in the final 15 minutes of the episode. You don't need to wait till the end to post those questions. In fact, if you wait to the end, you'll probably, if you're like me, you'll forget. So post them now or as you're listening, and we will get to those then. All right, so let's get into our topic today. What are we talking about? We're talking about South Carolina law. Sean and I have talked about on a number of episodes throughout the history of the NREM podcast about the topic of wholesaling. From a legal perspective, from an investor perspective, the problems, the advantages, the disadvantages, we've sliced it a number of different ways. And one of the things that we've said, and a lot of our guests have said over the last couple of years, is if there's going to be in any area of the law where we see regulation, we're probably going to see it in the area of wholesaling. And that's what we've seen. And one of the more recent states that have passed regulation to that extent is the state of South Carolina. So with us to talk about that is attorney Gary Pickren. Gary, thanks so much for joining us.
Hey, thank you so much for having me. I really appreciate it.
Yeah, we appreciate you taking the time. Now, Gary, you're a partner with Blair, Cato, Pickren, and Casterline in South Carolina. Tell us about your law practice, how you got into doing what you do.
Sure. I've been practicing law since 1995, and in that time frame, I've done 30,000 real estate closings. Our law firm mainly does real estate closings. That's what our bread and butter is. We do a little bit of estate planning as well, but we have 6 offices in South Carolina. I am just really passionate about working with investors, working with realtors, working with investors. I think that's one of the things we need to really kind of change that mindset and have these two groups work together. I know that's been a clash for years, but I think there's advantages for both to work with each other. I also am a real estate commissioner in South Carolina, so very intimately familiar with how South Carolina has come up with its law, as well as Pennsylvania's just passed its new law on wholesaling. And so that's kind of what we've been doing, and look forward to talking more about it today with you.
Yeah. So Gary, what are your duties and responsibilities generally as a commissioner in South Carolina?
So there's a practice act for real estate agents. It defines what the practice of real estate is, how you have to be licensed for it, and then it sets out all the rules and regulations for a real estate licensee, i.e. a real estate agent. And so as a commissioner, we sit in judgment of the real estate agents when they act outside of that statute. If someone practices without having a license. And then the other thing we do is for somebody wanting to become an agent, we have to make sure they meet the qualifications. And a lot of times that means talking about their criminal past, which is not always comfortable doing sometimes. You see a lot of bad stuff.
Now, have you been or are a real estate broker also?
Yes, I have a broker's license. I've had a broker's license for, 20 years. I teach real estate agent classes. I have my own podcast called Dish and Dirt. And, right now we've been spending months talking about the NAR settlement and how that affects buyers, sellers, agents moving forward. But so in order to be able to teach a lot of the classes that I teach, I had to get my broker's license. I don't actually buy or sell real estate using the broker's license, but I do have it so I can teach. But it also kind of gives me an understanding of what real estate agents do, why they do it, what their regulations are, to try to help them and help agents and investors understand working together is in everybody's best interest.
How often does your podcast air, and where can
it
folks
airs
find it?
Every Thursday morning? It comes out about 5 a.m. for our early risers who like to work out. I'm thinking about 200 episodes so far.
Okay, cool.
And they can find it on any platform. Just type in Dish and Dirt, DISHIN Dirt, and you can find it on any platform. Apple's usually the one most people find it.
Very cool. We'll jump on that. Tell us about. I understand you're the founding member of the installment method. Tell us about that.
Yeah, so when this wholesaling mess started coming about several years ago in South Carolina, it's now statutory, but it actually came out and started coming to the forefront due to a couple of matters before the Real Estate Commission. One involved a wholesaler, whether they were acting without a license, and we can talk about that later. And then a second one involved a real estate agent advertising and marketing property for an agent or for an investor. When I started seeing this, I sat down and talked to some of my investors. Some of my biggest clients that we've ever had in my 30 years are investors. And I tell that to people all the time. A good real estate agent might send you 1 or 2 closings a month, but a good investor themselves might send you 6 or 7 a month. And my biggest client is an investor in California, sends us so much business, refers everybody else to us. So once some of these cases started coming down, I started speaking with some investors in Columbia, South Carolina that I was friends with, saying, this is what we're looking at. And these guys were like, well, what are we going to do moving forward if we can't wholesale? And Adam, or I think it was Alex rather, said, how about if we looked at an installment contract for this one particular closing? And light bulbs went off on all of us. And we all just looked at each other and started laughing and said, that's the answer to wholesaling in South Carolina. And so we created a teaching program that teaches people the values of the installment method, not just in places where you can't use wholesaling, but even in places you can. It's kind of, I think as Pace Morby or Eric Brewer would say, you need to have as many arrows in your quiver as possible. Pace has created a tremendous program in Sub 2. Eric and his novations was so revolutionary. And they were a lot of the inspiration for us, were those two guys. But coming up with just another option, another opportunity that would give us different, each one does different things. And that's why we came up with it. And it's been very successful so far for a lot of our clients.
Very good. Well, let's dive into the topic. So we're here to talk about wholesaling specifically as it relates to South Carolina. So why don't we just start here? What is the law everybody's talking about? It's gotten a lot of buzz. Sean and I are out here in Arizona, a million miles away from South Carolina, and this came up on our radar screen right away. Tell us about it.
Well, once this law passed, I either became infamous or famous, whichever way you want to look at it. A lot of people said I was the one who passed it. I had nothing to do with passing it. The interesting thing about wholesaling in South Carolina is that we've seen this for many years coming. This wasn't like all of a sudden out of the blue this came. The Real Estate Commission, which I am a part of, had for many years prior to me even being on the commission, had this anti-wholesaling view. They looked at it as basically operating as a real estate agent without a license. And so the overwhelming opinion or belief of the commission was it needed to go away. At the same time, you had the Realtors Association, the same thing, wanting it to go away because they believed it was getting a commission without being licensed. And so, as I mentioned earlier, we had 2 cases that came before the Real Estate Commission. The first one that came before the commission said we had a wholesaler who had just done a simple wholesale deal, but the seller of the property brought a complaint saying that I had a contract with this guy to sell the property. The next thing I know, this real estate agent's advertising my property for sale. They're showing my house. I didn't know anything about these people. And to make matters worse, my sister tells me they sold the property for $30,000 more than me. So the real estate commission at that time opined that in order to wholesale, basically, you had to have a license. You could not market, you could not advertise property without a license. And so at that point, the reality of it was, if people who were wholesaling in South Carolina 3 years ago, they were getting cease and desist orders. If somebody turned them in and said, I believe this is a wholesaler, then they were getting cease and desist orders. One real estate agent I know had told me she had turned in like 15 people and her goal was to hit 50. She was turning in anyone who was emailing her, texting her about properties. It was a wholesaler. She was turning them in. So fast forward to last year, the Real Estate Commission had been approached by the legislature, and they said, with the Realtors Association's help, we want you to come in and revise the profession's statute for real estate agents. It's 40-57. And so at that point, we went in to clean up a lot of the rules and laws as it pertained to real estate agents. Had nothing to do with wholesaling, it's just fixing those problems. At that point, the commission decided that they wanted to use that opportunity to stop wholesaling. Now, I had to recuse myself because obviously I was working with the installment method. So I've been recusing myself from wholesaling matters for well over a year. But what I was able to find from watching what they were doing, because it was a live feed, was that they went in and put statutory language in, which essentially defined wholesaling, which we'll talk about, said in order to be a wholesaler, you have to have a real estate license. And then in perfect lawyer fashion, they turn around and said, now that you have a license, you can't do it. And so, people like Jerry Norton reached out to me and said, this seems stupid that South Carolina's doing it. I'm like, no, it's brilliant. They have no jurisdiction. So in order to create the jurisdiction, they have to say, in order to wholesale, you got to have a license. And then once they say, now you got to have a license, now I got jurisdiction over you. Now they can tell you can't do it. And so that's why the statute came out that way.
So a little bit more history as well. Tell us, when did the law get passed and when did it go into effect?
So the law came out sometime around April of 2024. It was passed very quickly. I had never seen how these things, behind the scenes of how these really are done in South Carolina. But once the Real Estate Commission finished what they wanted done in it, the Realtors Association looked as well, then it went to committee then passed it to the House and then the Senate. And it literally passed at like 11 o'clock the night of, or whatever the time frame was. They had to have it passed by a certain time frame, and it passed with like 1 hour before the session ended. If the session ended, it would have to start all over. And so I believe that was sometime in March or April that it passed. It became effective in May when Governor Henry McMaster signed it into law. As soon as it was signed, it became law. So it has been law, and it can be found at South Carolina Code 40-57-10. I will caution you, however, that you got to be very careful and look when you search for the statute to make sure it does say 2024 on it, because most websites are still showing the 2017 version of the law. A lot of them have not updated to put the new version on it.
Gary, let's break down this law a little bit as far as the language. So you mentioned it defines wholesaling. So what's the definition that they give to wholesaling? What is it?
Sure, that can be found at 40-57-30, which is our definition section. They've increased the definition from like 10 to like 50. The definition is number 44, and I'll tell you, I'll basically read it real quick to you. It says, having a contractual interest in purchasing residential real estate from a property owner. So you see there, it's residential real estate only. Then marketing the property for sale to a different buyer prior to taking legal ownership of the property. Advertising or marketing real estate owned by another individual or entity with the expectation of compensation falls under the definition of broker and requires licensure. So as lawyers, let's break that down. It's basically four components. One is the contractual interest, meaning you have a contractual right to buy the property. Number two is then you market and advertise the property to sell prior to taking ownership of that property, that you are expecting some form of compensation for that. And then fourthly, though it doesn't say it, obviously, it's done through some legal instrument such as an assignment. And that's basically what wholesaling. I don't think there's anyone reading that definition who would think that is not a proper definition of wholesaling. That's how I've always understood wholesaling to be. I think that's how everybody else, which then brings you to the second part of that definition, which I'm sure you're going to want to talk about, which says wholesaling does not refer to the assigning or offering to sign a contractual right to purchase residential real estate. And we can talk about what that means whenever you're ready.
Yeah, so let's break down the definition a little bit. So you mentioned that it only applies to residential. In Arizona, even though lending would define residential as a fourplex or less, in Arizona, ours is a duplex or less, would be residential real estate. How does South Carolina define residential?
1 in 4 family.
1 to 4 family?
Yeah.
Okay. Yeah. So ours is 1 to 2, but I know lending allows up to 4. So anything more than a fourplex, then this doesn't even apply.
Right. So
Okay.
you can do raw land is one that a lot of people have brought to my attention. There apparently is a lot of wholesaling in raw land. And even outside of the wholesalers, a lot of the builders, the way they do it would essentially fall in the definition of wholesaling. They sign a contract to buy land, they start doing their due diligence, decide they don't want it, but they have a friend who does. And so they assign it over and make money. I mean, technically that would be the definition of wholesaling. I think that's why they took commercial out of it.
Now, also within the provisions, it talks about for compensation,
Right.
as well as doesn't prohibit the assignment of a contract. So a lot of investors have their entity that they put down on the purchase contract, but that's not the entity that ultimately takes title. It's an affiliate. It's,
Right.
wholly owned by the buyer or by the members of the buyer. That would be fine then, right? At any point you could say, hey, I'm going to assign it to an affiliate during this transaction without an issue.
Right. And that's the thing here is when it says wholesaling does not refer to the assigning or offering to assign a contractual right to purchase residential real estate. The thing I think everybody needs to understand is not every assignment is wholesaling, but every wholesaling transaction does involve an assignment. So what a lot of people have tried to say is, oh, well, I assign contracts, so it says right here that assigning contracts isn't wholesaling. No, that's not what it says. You have to read the entire definition together to see what it means. What they're getting at, and just like you said, if I sign a contract to buy a piece of property, I decide I want to put it in my wife's name instead of my name, I can assign the contract to her. Clearly not a definition of wholesaling. I might decide to sign a contract to buy something and decide to put it in my law firm's name, Blair Cato Pickren. So I just assign it to there. That's clearly not marketing and advertising. I'm not expecting compensation for that. That's not wholesaling at all. Now, assigning it, however, when I found a piece of property under contract, I start marketing and advertising, and then I assign it to you and you buy it, that's clearly wholesaling. And so that's where a lot of people try to play semantics with it, but you can't. I mean, that's not.
Now, this definition is pretty broad, and it appears to go beyond wholesaling and encompass double closings and even novations.
I think so.
Yeah, you think it would include those?
Yeah, my firm's already taken the position as pretty much almost every firm except some guy that's in North Carolina has a South Carolina attorney. I think he sometimes does these, but pretty much every law firm we've talked to are not doing anything related to wholesaling. They're not doing back-to-back closings. And what I mean by back-to-back closings isn't that they're buying property A or selling property A and then at 10 o'clock buying property B, two completely different properties. But buying a property at 9 o'clock and selling that same property at 10 o'clock is a problem. And the reason being is, how did you market and advertise the property without becoming the owner? And you can't tell me you closed at 9 o'clock. And from the time I dispersed the check to you at 9 o'clock, we found an owner, searched the title, got the loan in process, and closed it all in 15 seconds. It's just not happening. So, most lawyers, because we are, everybody's like, well, you're not the police of it. Yeah, try to tell that to the federal government. We are the police of the real estate transaction. And I don't know how we can pass the giggle test that we did back-to-back closings and we know there was no marketing or advertising. It's just the rare occasion. Sure, it could happen. Rare, but I'm not risking my law license. I don't think you would either.
Yeah. So that raises a question. Have you guys put in, what your presumptive time frame is for the turnaround sale by an investor on a property?
So first of all, our firm, as most of the firms we're talking to, will not do an assignment closing at all. If there's an assignment, pretty much the general rules, we're not going to do it. Now, if it's an assignment from you to your law partner and you say, hey, look, this is me, I'm signing it to my law partner, there's no compensation. Those rare occasions we do, but an investor saying, hey, I promise this isn't wholesaling, we're not risking our law license for that. As far as the back-to-back, what we're saying is the contract cannot be dated until you take title.
Okay. That makes
so once
sense.
you take title, then you can give me a contract. And because I've already done the title search, I can probably close it in a day or two. but we're not going to accept any contract or open a file on it until you're on title or an ownership interest, which we can discuss under the installment method.
Now, I've also heard some commentators, attorneys say, okay, and in some ways you've answered this already, but we'll dive into it. On that second half of the definition saying, hey, you can still assign a contract. That's fine. I've heard people say, well, you just market the contract. You say, okay, I have a contract to buy a single family home, 2,000 square feet, 4-bedroom, and you describe the property, but you don't give the address, don't give photos, don't do anything like that. Maybe just give her general vicinity. And they say, oh, well, you can do that. You can market the contract. And then if somebody's interested, then you send the contract over to them, and then they can do their own due diligence or research on the property. And it sounds like you're taking the position like that may work, but we're not going to get involved in that.
Well, and there's 2 points on that. Number one, you're right. As a lawyer, am I willing to risk my law license? What lawyer do you know that would be willing to risk their law license playing semantics with this statute? As lawyers, the bar is very clear. We are not to assist anyone in skirting the law, violating the law. And so if we're wrong and you have been marketing and advertising the property and not the contractual position, then it's our law license. You know, you might get a small fine. I can lose my law license, which lose my law firm. So that's the first part. But the part about it is the statute. Let's look at the second part of the statute. South Carolina Code 4057-135. This is what it says. An advertisement that markets a contractual position to acquire real property from a person, either equitable or legal title, and does not imply, suggest, or purport to sell, advertise, or market the underlying real property is permissible under the section. So simply put, you can say you may market a contractual position as long as you don't imply, suggest, or purport to sell, advertise, or market the real property. How do you do that? So let's take a couple examples. I have a contract for sale. Here's a picture of a property. Did I not just imply that there's underlying real property? Certainly I did. If I put a description without putting a picture, I have a 2-bedroom, 3-bathroom house, contract. Did I not just imply there's underlying real estate? Of course I did. If I put a tax map number, an address, that's implying that there is underlying property. So the reality of it is, while a lot of people have looked at this statute and goes, look, I don't sell. And I've seen these crazy disclosures, like these big red disclosures. I am not an owner of this property. I'm not advertising the property. I'm just offering a contractual position. That's like saying I'm not a drug dealer. I just sold you the baggie in which the drugs came in. I mean, come on, people. I mean, you can sit here and play this crap all you want, but the reality of it is that's not going to stand up. I don't know any way you can do it except one. Let's say that I know that Sean and Andy are big investors and they have 50, 100 properties going at any time. I pick up the phone and call and say, hey, Sean, Andy, tell me, do y'all have any properties? I'm looking for something over here in Greenville, South Carolina. Do you have anything that you might be willing to sell me? Sure, I got this contract. You didn't market and advertise it. I came directly to you. I think that might work, right?
Right.
Except find a lawyer who's going to close that.
Right. Because you have to prove that, right? You have to,
right.
And you're not going to sit there generally and rely upon some statement by an investor saying, well, I never marketed it.
Right.
And how would you actually establish that?
Right. Because the bar doesn't care that you lied to me. They don't care. And people need to understand South Carolina is a lawyer state. What that means is all real estate transactions have to be closed through a lawyer. We are responsible for title review, title insurance, recording of the documents. We're basically on the hook for the entire transaction. And the South Carolina bar, the South Carolina Supreme Court doesn't really care that you might have lied to us. We're the eyes and the ears. We have to make sure that the transaction is being done properly.
So you went through a background of, the parties in favor of the law, but was there anything underlying, some bad actors, something going on in South Carolina where, all of a sudden South Carolina is like, we just got to get rid of this type of transaction,
Right.
Why exactly was this passed?
Well, like in any industry, there's some terrible lawyers that shouldn't be practicing law. There's some terrible lenders who shouldn't be out there. And unfortunately, in the investment space, there are some bad wholesalers, and those are the ones that go out there and sign a contract, no intention of ever closing it. They market it. They can't sell it because they don't know what they're doing. They get extension after extension after extension, and then eventually they just ghost their client. And then the seller's stuck there with no closing, no ability to go after the seller, don't have any way to really get in contact with them, and the earnest money was never paid. And so what happened, in my opinion, is the cases that kept coming before the real estate commission was usually somebody who was older, a minority or a woman, and they would come up and say, I've been taken advantage of. I sold my house under a contract to Andy for $100,000. And the next thing I know, Andy's not returning my phone calls, and Sean pops up, and I don't know who this Sean guy is. And all I know is that he paid Andy $50,000 and I still got $100,000. And it's a compelling argument when you sit there in front of real estate professionals saying, this isn't right. Why didn't you just hire a real estate agent? The real estate agent could have got you $150,000. Now, let's be honest about that for 1 minute. That's not necessarily true, because if it was true, CarMax wouldn't exist. Because I can sell my own car for a whole lot more money if I market and advertise it myself versus going down to CarMax. But why do I go to CarMax? I don't want people coming to my house. I don't want to test drive a car with somebody. I don't want to hope their check doesn't bounce. I don't want to hope they don't kill me and take my car, right? I like the convenience of just taking it down there, handing the title, getting my check on the spot, right? Even if I sell it to you, it might take 2 weeks to get the check done. And so people sell real estate the same way. Some people don't want to deal with an agent. They don't want people in their house. They don't want to have to make repairs. They're willing to sell it for less money because they have certain needs right now that need to be taken care of. So I don't necessarily subscribe to every wholesale deal is taking advantage, and they kept calling it equity theft. I don't believe that for 1 minute. I think the investor is an absolute necessary part of the real estate economy, 110%.
So let's talk about some of the potential workarounds. Another, in addition to, marketing the contract, one thing that I've heard people suggest would be to use a single asset LLC, put it under contract, and then market your membership interest in that LLC for sale, and basically assign, the membership interest as part of the transaction. Is that still a violation?
No, they can do that. It's just very expensive and very risky. I mean, as a lawyer, can you imagine the risk you're taking when you buy an LLC? Because when you buy the LLC, you're buying all the liabilities, debts, and so forth, whether they're known to you or not. Now, you can always sue the other side for not disclosing, but they're gone. Right. So there's a lot of risk in doing that. Plus, the cost of it would be just, not astronomical, but very expensive. I think there's other avenues that are a lot easier and cheaper. But I've had people ask me all the time, sure, go right ahead and do that. You're going to pay $5,000 probably for that transaction. And there's a lot more risk in doing something like an installment contract that we talk about. Another
method, and this is one of my pet peeves because I don't think people do them right, are land trusts. So you basically form a revocable trust. In this case, presumably the buyer would be the grantor, would create the trust, put the trust as the purchaser under the contract, and then at closing assign the beneficial interest of the trust to the end buyer. Is that something that's, workable under the statute?
Yeah. The problem with both of those, though, is remember, you still can't market the property until you own it. So it's still, because I remember that's the definition here. I mean, in South Carolina, you may not market or advertise property until you have an ownership interest. So even if you set up an LLC, you set up the trust, until the trust takes title, we're not selling it. So or marketing it or advertising. So once you take possession of it, you're still 30, 60, 90 days away before you're going to be able to sell it to somebody else. So you're still having to come up with your money to purchase the property and do the rehab yourself. So I don't necessarily think it covers or takes, that's what the wonderful thing about the wholesaling was. I didn't have to put any money in. I could go buy a $200,000 house and never put, other than some earnest money down, much money in it. I think under both of those, under South Carolina law, yeah, you can still do them, but you're going to have to buy the property. You're still going to have to go to Pace and get Gator financing or something and pay and buy it.
So in Arizona, we call installment contracts, executory contracts. We call them agreements for sale. In Wisconsin, where I'm also licensed, we call them land contracts. And I think in South Carolina, you call them land contracts.
Installment contracts mainly, or bond for titles.
Bond for title. Okay. It's all the same, just semantics. But talk to us. Is that a workaround for this law? Is doing a short term, some type of contract for deed or installment contract?
Absolutely. And full disclosure, again, we created the program installment method. So everybody, well, he's got financial interest. Sure. My financial interest is I'm one of 8 owners in a company that makes about $100 every time we sell one. So I'm, really making a lot of money here on this stuff. So, but, let me just give you the quick background of installment contracts and why they're so beautiful. They have been around since the 1800s. They have been around in every single state. Every single state either has case law on it or statutory law. They were done back in the 1800s in a bad way in a lot of places. Chicago, they were being done, and they were done in a discriminatory way. What they were done is that white people who own property would sell them to African Americans, and then the second the African American didn't make a payment, then they would take the property back, and the African American would lose all the money. Then they would sell it again, and the rates were like 19%, 20%. So they were very egregious. A lot of the laws in the case law came in to protect the buyer. In our program, who's the buyer? The investor. So for the first time ever, we have law that actually protects us instead of harms us, right? So, so the installment method's very good. They were very popular in the 1990s. My brother bought and sold houses using them himself for his personal use. And the reason they were big in the 90s was lending was very tight. Buyers couldn't get loans if they had any blemish on their credit. If they couldn't prove income for a certain period of time, it was a buyer's market. So sellers would take any type of offer they could get. What we have done in our installment method program is we said, look, those installment methods back in the day, or installment closings, bond for titles, all that, they were for 24, 36, 48 months. And they had a very bad fallout rate because you're typically were a seller who had bad credit selling to a buyer who had bad credit. After about 8-10 months, the payments wouldn't be made and it would all fall apart. But what we said is, look, why don't we take these transactions and make them into short-term transactions, 60, 90 days, so we don't have this long period for things to fall apart. And when we do this, every single state in the country, we noticed, recognizes that when you have an installment contract for deed, you do have an ownership interest in the property. Not only do all the states recognize it, FHA, VA, conventional lending programs all have guidelines on how to close and refinance installment closings. The IRS has taxing guidelines on how to tax a transaction. Title insurance companies from Chicago Title to the Fidelity, you name it, they all have underwriting guidelines. So when we start looking at, we're like, look, we got the legal backing here of this program. And so that's what we started teaching, is teaching people to buy using the installment method to do 60, 90-day transactions, which now gives you the ownership interest, which means now you can start marketing and advertising the property the second the installment contract is closed and recorded.
So to break this down, basically what the reason why an installment contract or a contract for deed or bond for deed does not fall within the regulation is because you actually are creating an ownership interest in the property. Now, is the installment contract, is it recorded?
Yes, we record it. And that's what I really like about this. And this is what sets the installment method back out from wholesaling, right? When you have wholesaling and I've agreed to sell my house to Andy, and then he flips it over to you, Andy's gone. And so anything Andy and I have agreed upon, unless it's in writing, it's just gone, right? There's no transparency to that transaction. I don't even know who you are, how you came about, how much money in most situations. But with the installment contract, I'm only dealing with that one investor. It's not being flipped to somebody else. The transaction is with me and that investor. It's 100% transparent. It's recorded. There's actually a closing that's done when we do the installment closing. We actually do a settlement statement. We go over the documents. So there's full disclosure, full knowledge, full transparency, which is why the real estate commissions across the country look at them and go, okay, that's fine. Because they know all of the problems with wholesaling, the lack of transparency, the buyer going away or the buyer being changed on you, nothing being recorded, no lawyer being involved, no title company being involved, all gone. Now, what I like to tell you about why I really like this idea is it kind of flips the script a little bit. The one thing I'll tell you in wholesaling versus installment methods, when I'm a wholesaler, my job is to push you as the seller down as far as possible on price because I'm going to flip it to another investor. So if I'm going to flip it to another investor, that investor has got to get me down so there's still enough money for them to make profit. There's not an indefinite amount of profit or infinite amount of profit in these things. So I got to push the seller down. With the installment method, I don't have to do that anymore. And the reason being is I don't have to sell to another investor. I'm now selling on the open market in the MLS with a real estate agent that I hired. I'm willing to pay 6% to, because she's going to sell the house for me to an end user who on average pays 66% more money than a wholesaler gets it. I've had all of our clients that we've run the program through have told us the same thing. They were averaging 15 grand on wholesaling. They're now averaging 45,000 on the installment method. They're making a lot more money. When we're able to make more money in that manner, what does it do for me? Now I can attack it in a way nobody else can attack it. I go to the buyer and say, or seller and say, Mr. Seller, what is your pressure points? Why are you needing to sell this house? As we just talked about with CarMax, not everybody has the same reason to sell the house. And so I can craft my transaction to meet the seller's need. I can offer more money because I got more money to play with. So I'm going to beat every wholesaler, but I can beat everybody else also because I can craft it, right? I'm going to do a 90-day installment contract with you. What's your biggest reason you can't sell the property? I got nowhere to go. I got no houses. How about if I let you keep possession of the house for 60 of those 90 days and you don't have to pay the mortgage payment? I'll pay it. Your payment's $1,200 a month. I'll make the mortgage payment for you during that time frame so you get to live free for 60 days. What seller isn't going to jump on that?
Right.
And so it allows me to flip the script to make it more seller-centric versus investor-centric, even though it's still investor-centric. But if we can make the seller, we can find their pressure points and resolve those pressure points, I'm going to get more contracts than everybody else.
So if I'm a seller, though, I'm pushing back a little bit, saying, okay, this is going to be a recorded document. And, obviously I'm coming at this from an attorney knowing what I know, but, if it's a recorded document, and what happens if we get to the 90-day point and you decide you just can't perform, you can't pay the balloon payment or whatever it is on that 90th day, how do I get my property back?
Two ways. Well, in South Carolina, each state does it different. So I can tell you in South Carolina, you do have to foreclose on that interest. You can't just evict. It's got to be a foreclosure. But there's two things to understand. One, if the buyer doesn't perform, the seller could sue them for non-performance, right? And you got to record a document saying what your performance is. And so I can sue you for my damages for performance. But the reality of it is this. If I do a 90-day deal with you and I should be able to make 66% more money, if I've blown that, I shouldn't be an investor in the first place, right? Because if I can't value within 66% of what this property is worth, then I'm an idiot. But let's just suppose something happens, the economy collapses like yesterday when the stock market collapsed, and say, I can't get out of it. What I can do is I can go back to you as the seller and say, look, I am very sorry this didn't happen, didn't work out the way it's supposed to. I'm not a bad guy. I'm not trying to screw you over. What has to happen now is you got to foreclose on me in South Carolina. That's going to take you about 18 months, 12 months, 18 months, and it's going to cost about 5 or 10 grand. I'm not that guy. I'm going to convey it back over to you through a quitclaim deed, canceling the transaction. I'm going to let you keep the down payment and the monthly payments I've made. And in exchange for that, you'll just sign the release saying that we've released a contract. Now, a seller's going to go talk to the lawyer. And what the lawyer is going to tell them is the same thing. Well, in order to get rid of them, you're going to give me 10 grand and you're going to go to foreclosure. And at the end of the day, you'll get the property back. They're giving it to you back now without any effort and letting you keep the money, accept it and go away. So that's the reality of these matters.
So to make a seller feel comfortable in that case, because obviously that's on the back end where they don't perform, can the investor say pre-sign that quitclaim deed and deliver it to escrow with instructions?
Well, no, and the reason being, and I don't recommend that. Maybe some states you can, but certain states like Georgia, New Jersey have requirements that once the deed is signed, it must be recorded within a certain number of days. So lawyers aren't allowed to hold them. Title companies aren't allowed to hold them in escrow. As a lawyer, in order to have a valid deed, it's got to be signed, sealed, and delivered. And so there would be some argument that holding the deed in trust means that you didn't have delivery of the deed. Most of what we've seen so far in the year that we've been doing it with our investors is the sellers aren't concerned about that. If you're a good investor and you can show them a good track record of closing and show them and be honest, and that's what the whole idea of this is that investors to be upfront, honest, and transparent, then we don't have that problem. And we haven't seen that our sellers are really worried about that. Most of them have financial problems they need taken care of, or they have nowhere to go and they need that situation taken care of. And that's their biggest concerns.
You mentioned one of the advantages is the end buyer can purchase with financing.
Mhm.
I know the VA, FHA have like an anti-flip rule, which requires, seasoning of that property by the investor. What happens if you have an end buyer that comes forward and, they want to close, but VA, FHA won't fund because of the anti-flip rule? Is there a workaround that you guys have come up with?
So everybody understands all this. If it's a cash deal on the back end, that's fine. If
Right.
it's a conventional, there's no problems.
Right.
VA under an installment does not have a seasoning rule. So VA, you can close a VA loan without the seasoning rule. The FHA seasoning rule is 90 days from the seller taking ownership interest. They don't define it as deed recording, which is the problem. So some lenders, and this is where it becomes an underwriting issue because I've researched this tremendously. I talked to 6 different lenders. 5 lenders told me they look at it at the day that the installment agreement was recorded. Once that's recorded, that starts your 90 days. Once you hit 90 days, then we can go under contract, then we can close it. The other lender said, no, we're very conservative in how we read that. We read that as deed, once the deed is recorded. So we can't do an installment closing period that way. Now, the interesting thing is if you think about it from a deed, what they're saying is I could do a 30-year installment contract, make payments to you for 28 years, and 2 years before paying it off in full, I sell it to somebody else. And they're like, oh, no, that's a flipping rule. That's clearly not flipping. So that's why I don't believe the one lender's right. But it ultimately comes down because there's no guidelines. There's no clarification of the statute anywhere. It's kind of a lender-to-lender decision on that. What we found is when they go by the 90-day rule of recording of the installment is we're telling people, go ahead and get a letter of intent signed saying that I, the buyer, will, once we get to the 90-day mark of your ownership, we will then record, we will sign an installment agreement with you, we'll sign a contract to buy your property. And then we sign the contract on the 90th day. We may have to do an extension with our seller to get it to 120 days. You get that by paying them more money, which you get credit for, right? If I give them $5,000 to extend it, it comes off my purchase price.
Right.
So it's not losing the money. That's one way. The other way, if they will not do it, if it just can't work that way, is the lender gave us 2 suggestions. One is you go back to the original property owner and have them sign the contract as well. And then they sign the deed with you as well, which means they're going to find out how much money you made, which may be okay if you've done a lot of renovations. They don't care. The other way was go ahead and have them record the deed. I would never do that as a lawyer. I mean, why would the seller convey the deed if they hadn't been paid in full? So that's one way of doing it. And I guess they could record the deed and take a mortgage back, but you're still behind that other mortgage. At that point, you're sub 2.
Right. So it sounds like under the first method, what you would do is basically you would have the contract between the original property owner / seller, the end buyer, and then you would unwind the installment contract but only effective upon closing. So you would get your markup or whatever.
Yeah. How that lender wanted, that one wound up closing. Eventually what that lender did is they went back to underwriting and got that underwriter just to let it close based on the 90 days. And I will tell you this, out of all of our clients that have done these, we've had one FHA that was an issue. And that was only one. And that one wound up resolving itself. But yes, I think the way it would be is, I still have my installment contract. And then what I would do is have the seller sign, I would sign. So both of us are signing the contract. He's selling the legal interest. I'm selling the equitable or contractual interest, whatever we call it in each state, to the end user. And so we all signing it. And then we'd have to have an agreement signed as to the distribution of proceeds.
What happens under this method if because obviously with the land contract, title is still in the name of the seller. And so you find your end buyer, you fund escrow, you're ready to close. And the seller's like, yeah, I'm not signing that deed. What does that mean? Do you need the seller's cooperation? What does that look like?
So you do need the seller's cooperation, but the reason they're going to sign that deed is their mortgage isn't getting paid off until you pay them in full. Because most of these deals, let's just use some made up numbers here. I'm paying you $200,000 for your house. I'm going to give you $1,000 down payment. $199,000 in 90 days. Well, in 90 days, this seller still wants the remaining portion of their equity, whether it's $500 or $5,000, and they still need their mortgage paid off. So none of that happens until they come to the closing of the B2C transaction, sit in the lobby, and then sign the document, the deed. Then we hand them their check. So there's very much incentive for them to come and deal with it. If they don't deal with it, I still have the right to sue them for non-performance, and I have a recorded document now.
Right.
That's a big problem in wholesaling, is that, I've got a contract, and the next thing I know, I go to close you out and find out you sold it to somebody else. Well, you're not selling it to somebody else with us, because I've got a recorded document of on title.
So basically, if I understand correctly, under this method, the only document that the seller signs so that the end buyer can purchase is the deed. They don't sign a settlement statement. They don't sign any of the closing documents. They simply sign and deliver the deed.
Right. We treat it as an A to B transaction and then a standalone B to C transaction. On the B to C transaction, they sign the deed, and there's a payoff to them on the settlement statement minus whatever liens we have to pay off.
How does insurance work during that 90-day period? Who's responsible for it? Who's the primary insured? The whole thing. How's that structured?
So we tell the seller, do not turn off the insurance. Your lender's requiring you to have insurance, so keep your insurance in place. And then we tell our investor, if you're worried about, you go get your additional insurance policy if you're worried about that. And we don't give advice on insurance. So we tell them they need to talk with their insurance advisor. But what most of their insurance advisors are telling them is, the title's still in the seller's name. Seller's still got the insurance. House burns down, the insurance will take care of that. Any money that you've put into the property, if you've put in, renovated the kitchen, you might be exposed there, or you might need to look at doing a renter's policy or something. But for them, we advise them to talk to their insurance companies about that.
Yeah. So it sounds like that what the insurance professionals are saying is that the seller still retains an insurable interest in the property by being, still on title.
Right.
And because of that, they can maintain the insurance in their name. Has there been any recommendation that the purchaser come on as an additional insured?
No. And, these things are for such short periods of time, 60, 90 days. I've been doing some for 15 and 20 days. So we have not run across that yet. Our insurance companies have not told them to do that.
So does South Carolina have transfer fees? So when you record, say, a installment contract, in some states, we don't have them in Arizona, we have them in Wisconsin, you have to pay sometimes a pretty hefty, tax or fee for the transfer of the property, even on an installment contract. Is that something you have in South Carolina? And how do you guys do it?
Not for the installment contract, only on the deed. So when they do the closing, that B to C, you got deed stamps on the A to B deed and the deed stamps on the B to C deed. So you'll have the two deed stamps at the B to C. So our investor, who will be the seller on the B to C transaction, they'll typically wind up paying both deed stamps. One of the things we do in our program is we try to keep it as simple for the seller as possible. So being that you're getting 66% more money, factor in those costs. And basically what you want the seller A to pay is the sales price minus whatever they're getting for the down payment and all the other fees covered by the buyer, which would be the investor. We tell them to figure these numbers out in their deal. Because it just makes it a very clean, simple deal. It's hard for the seller to argue they were taken advantage of when they didn't pay a single fee to sell the property.
Right. Now, for the situation, you mentioned that there's times where the sellers are going to retain possession of that property for at least a period of time. You mentioned one of the negotiation possibilities is to basically say, hey, I, as the investor, will pay your mortgage payment for you. Is there ever a situation where they could negotiate where basically the seller remains, and as rent, basically they just pay the mortgage every month? Can that be negotiated?
The sky is the limit. And that's what's so beautiful about these things. We have done them where the person leaves as soon as they sign the installment method. We've had them where they stay 10 days, 30 days, 60 days, 90 days. We've had it where the investor pays the mortgage payment. We're having it where the homeowner pays the mortgage payment. One of the most interesting ones we had, nobody could get this guy to sell his house. My investor went to him and said, why won't you sell the house? He goes, it's November. I know I'm losing this house to foreclosure, but I cannot leave because I need my children to be here during Christmas. So they went ahead and closed on an installment, let the guy stay through January. They let my guy go in the house and renovate the kitchen and the bathroom. The family's just told the kids, we're going to sell the house. We're getting it ready to sell, but we're not going to move until after Christmas. So Santa Claus will still know where to come. And then what my investor did, we wrote it into the deal that above a certain dollar amount, he would split the profit with the original A at 60-40. So talk about giving an incentive for a seller to sell it. My investor wound up making almost $100,000 on this deal.
Mm-hmm.
And the homeowner wound up doing everything he could. He helped do some of the work in the house. He was cleaning. He was getting the yard ready because he knew he had incentive to get that profit dollar up for him because he's going to make some more money. So the sky's the limit with them, because in our program, we teach you how to come up with all these different methods and all the different ways to convince sellers to sell the property and how to write those in our contracts.
So this method obviously came out of forthcoming regulations, interpretations of the licensing laws in South Carolina, and was targeted to South Carolina. But it sounds like this can be used nationwide. And in particular, one of the types of transactions I always hate, some clients do them, but I hate them, is novations.
I know Eric Brewer very well.
Yeah. He does it on a volume and does a good job, but not everybody's Eric Brewer. Right. And so I just hate them. It just seems like there's so much risk, liability concerns, et cetera. And this type of transaction seems like it can replace novations and be a safer transaction.
So we did a lot of research. We had a team of 5 lawyers. My law firm's half owner of this program, and then our investors were the other half. And there was a lawyer in that investment group. We painstakingly went through every single state, looking at their case law, state law, to make sure it was legal. But the wonderful thing about our program is you can buy the national program, and it teaches you about how to do it nationally, but we're starting to come up with state by state. So the installmentmethod.com is the national program, but if you just want it for South Carolina, we have the installmentmethod.com/South Carolina. We're getting ready to come on board. Then by the end of this month, we'll have North Carolina, Georgia, we'll have Tennessee, Mississippi, Texas, basically every southern state we're going to have, Florida. And so what we're doing is slowly adding each individual state. When you buy the national program, then you'll also get access to the individual. Well, what's neat about the individual states is the individual states will come up with a contract that has been reviewed and approved by a licensed lawyer in that state. The installment agreement that's recorded, that's been reviewed and modified by a lawyer in that state. And then you'll get the contact information from that lawyer on how to work with that law firm to do the closings. So by getting the individual states, you get the individual lawyer that knows how to do it, has gone through our program, understands it, and is willing to close with you. But yes, we think this is a good program nationwide. The only state we're concerned about, there's a couple of things I do need to add. Texas has subchapter D, which is a crazy law, but it doesn't apply to installment contracts if they're less than 180 days. Ours are 90.
Wow.
So our lawyer, one of the lawyers that we're working with in Texas, is his program where he's coming in to help us with that /Texas is an instructional video saying you do these for 90 days, 120 max. We don't do them anymore. Anything above that, we got to avoid. But even if you went into subchapter D, it just adds more disclosures. It doesn't kill them. Pennsylvania, on the other hand, they got a new wholesaling law coming out in January. It's already come out. It's effective January. The definition of wholesaling is so broad, who knows if it includes installments? I don't think it does, because there's a separate statute for installments. I'm in the process of writing a letter, which will go to the commission, asking them to opine in Pennsylvania as to whether installment contracts would be. But no, I think this can be used in Chicago where they have problems. I think it can be used Texas, North Carolina, Georgia, Florida, you name it. Arizona. And the thing about it is, even if your state says wholesaling is okay, y'all still do sub-twos. You still do novations when the product is better. I think installments are better than wholesaling because I have an opportunity now to list properties with real estate agents, make more money, I'm using the seller's equity in order to do that in terms of buying it. It just flips the script. And I just think it's a better program than trying to wholesale. And I think Pace would probably agree, and I think Eric would agree that their programs are better than just plain wholesaling. And I agree. So I just think this is a better program. The thing I will say about this, it wasn't a year ago where everybody was saying, Gary doesn't know what the hell he's talking about. Wholesaling is going to be legal forever. And here we are. South Carolina's outlawed it. Pennsylvania's outlawed it. Do you think as a lawyer, that's the end of it?
No.
It's just going to keep going. Once one state does it, they all do it.
Yeah. Yeah. The states follow each other all the time. So I think, not every state's going to outlaw it, but I think you're going to start seeing some dominoes, following that. So last question, then I'll turn it over to Andy to close us out. This is fascinating. I this is just such a unique and novel way, of transacting. So you mentioned you have two contracts. You have a purchase contract, and then you have the installment contract. Are there states? I know in Arizona, I just use one form, which allows you to open escrow and everything, and it's not notarized at first, like a purchase contract, and then it's delivered to closing, and then it's notarized. Are there states where you just have one contract, or are you always breaking it up into two?
So how we're doing it is, in order for me to get the seller to sign to sell the property, he and I have to enter into some type of a contractual agreement. Yeah. So that's the contractual agreement. The second document is the actual contract for deed that gets recorded. So we're not recording the first one because the first one's usually being written by buyer and seller. There's scratches all over it. They're not filling in all the blanks. It's done wrong a lot of the times. So we're taking that agreement, which very much mirrors what we record. I'm taking that as a lawyer. I'm implementing those terms into my actual agreement that I then record. So that's why we're doing it as doing it two ways.
Very good.
I do not want to record the A to B transaction where they've written it themselves, because I can guarantee you there's stuff in there that's not done right. It's just, they're not lawyers. So we got to fix it, right?
Right. Yeah, exactly.
And that's not a slam on the investors. They're just not lawyers. And so, that's why you pay us to make sure it's done right.
Right. Exactly.
Protect you.
Right.
Well, Gary, thanks so much for joining us. I was just sitting back here enjoying the lawyer transactional Super Bowl here. I know Sean was gearing up for this for some time. But we, like I said, we've been tracking wholesaling for a long time. Boy, when we started this show, it was right around the time Arizona itself passed a wholesaling law. And it's just, we see regulation coming in the space of real estate. This is prime for it. We really appreciate your time. Gary, tell our listeners how they can find and connect with you.
Sure. Installmentmethod.com is our program. Right now, as I said, we have installmentmethod.com/South Carolina. We will be adding all the southern states, I hope, within the next 2 or 3 months, but you can always go back and just type it in, add / the state you're in, and see if it's up yet. Texas is coming in very soon as well. You can find me at Blair Cato, BLAIRCATO.com, and my email is Gary@BlairCato.com.
All right. For those watching on YouTube, we have in the description of the video link to all of the ways to connect with Gary as well. So go there, click that. Gary, thanks so much for being with us. Let's do this again soon.
Appreciate y'all having me. Love to come back anytime you need me.
All right. We'll do it again. With that, everybody, that is our show. Thanks for joining us. Make sure to join us next week. We'll see you then.
Have a good day, everyone.